January 16th, 1989. Virginia Industrial Commission attempts to dictate my life. Deny religious freedom. I appealed an Industrial Commission workers' comp decision denying full benefits based on my former employer's continued false claim that I had been terminated for fault and for my refusal of job offers from the employer's agent on First Amendment religious grounds. Number one, I refused to sell meat and tobacco products as a cashier in a convenience store. Number two, I refused to shave my beard in order to work as a security guard. They wanted me to shave my beard to take a job. The opinion dated January 11th, 1989 contained defamatory factual errors and denied my First Amendment right to freedom of religion. Basically nonviolent vegetarianism and my right to wear a beard. January 17th, 1989, I completed the ICS course for legal assistance. January 19th, 1989, the second desertion. Kathy attempted to provoke me by entering my room uninvited. We, at this point, were living in separate bedrooms. I gently nudged her out of my bedroom to avoid further contact. The next night, there was a false accusation of assault. Kathy again attempted to enter my room uninvited to provoke me. When I started to again nudge her out of my room, she straight-armed me back into my room in retaliation for the previous evening. It was a preemptive strike, so to speak. So I just responded naturally by pushing her out of the room. She pushed me and I pushed back, pushed her out of my room. This was my private space for the purpose of avoiding her verbal harassment as per our pre-separation contract, which she was invading. She was invading my space. My pushing her was a spontaneous defense to her premeditated attack on me in trying to force her way into my room. I then called the crisis center to obtain advice on how to avoid further attacks, provocations. Kathy overheard my conversation with the crisis center, then called them and lied about the pushing incident, exaggerating that I had brutally attacked her. She was able to leave with the children under police protection after falsely accusing me of assault. We both filed assault charges. I figured since she was getting away with it, I needed to try to defend my rights. I was charged and arrested due to police policy of presumption that the man is guilty in such cases. There's a pro-arrest policy, probably in many counties across the nation, that in domestic disputes, the man is arrested just to break up the two from any possible, it's a preemptive arrest is what it is. So they remove one of the parents. It just happens to be the man. Lucky me. Kathy was not charged. I was charged. My case was later dismissed. And may God strike me dead if I have exaggerated one bit. I did not assault her ever. February 8th, 1989, the Juvenile Domestic Relations District Court stole my children without legal justification. The judge, quote-unquote, Robert M. Jacoby, Newport News Juvenile Domestic Relations Court, granted sole custody of the children to Kathy, allowing me only supervised visitation at the in-laws' residence for 4 hours on Saturday and Sunday every 2 weeks, even though I had been prime caretaker of the children prior to separation. It was as if I was being punished for being the prime caretaker due to my injury. I was prime caretaker due to my injury. I was a stay-at-home dad. I appealed to the circuit court. I was shocked, confusion, and desperation at having my kids stolen from me I was forced to quickly settle my insurance claim for a lump sum award in order to pay large legal fees and to attend paralegal school to retrain myself to earn a living. March 8, 1989, at the assault hearing. They continued the hearing until August 1989, pending dismissal upon good behavior. Though the case was later dismissed in August 1989, the assault charge was hanging over my head and used as a weapon against me in civil court, in both the juvenile custody hearing and at the custody appeal hearing on April 24, 1989 in the circuit court. It's as if double jeopardy didn't exist because they try you twice, 3 times in my case, even though the assault charge was dismissed. They have to try to demonize you somehow. That's the game they play. So in the circuit court appeal, April 24, 1989, the circuit court affirmed the unconstitutional custody order which stole my children. Judge, quote-unquote, Robert W. Curran, Newport News Circuit Court, claimed to believe Kathy even though she changed the assault story each time she told it in court, 4 different times. The judge affirmed the sole custody order, but allowed independent visitation every second weekend and for 4 hours on Monday, following non-visitation weekend. Basically, they had me in handcuffs and shackles on my ankles, and they maybe, so to speak, took the shackles off my ankles now. So first they take away everything and piecemeal give you a little bit back so that you think you're gaining something in court, I suppose. A few crumbs from the divorce industry table. In the divorce game, lawyers, in playing the rescuing champion of an allegedly abused parent, they have to villainize the losing parents in a false justification for destroying a family. Imputed wages. The court imposed extortion and slavery on me. The original support award, upheld on appeal, imputed my wages to $20,000 for child support purposes. After 1, I had lost my occupation due to injury on the job. And number 2, I had debts from retraining. 3, when my highest wage ever had been $16,000 per year. They set my income at $20,000 with all my debts. May 1989 to January 1990. I moved to Arlington, Virginia to attend paralegal school. I had a brother who lived in the area, and I needed to retrain somewhere. I still wanted to go to law school. I completed the full-time program at the Paralegal Institute with the highest grade to date on the comprehensive final exam. January 1990, I moved to Norfolk and worked as a title abstractor to be near my children, but meager pay and debt from school prevented me from paying extortion after November 1989. My insurance money from the injury had run out at this point. In May 1990, my attorney abandoned me, attempted to have me sell my children, basically. The divorce hearing began after my third attorney, Darrell Harding, coaxed me, literally as we entered the courtroom, into waiving fault grounds by promising that the scope of the hearing would not be affected and that this would help in addressing the custody issue. Judge Curran stated he did not have time on his docket that day and continued the case until December 11th, 1990 for a full day hearing. He said we needed a full day. So he postpones the case. This is another tactic of the divorce industry. They keep postponing justice while justice delayed is justice denied.